Madeline is my very good friend, and she's the founder of iResolve Limited, a boutique corporate arbitration and dispute resolution firm in Tanzania. She's practicing commercial and corporate law and has acted as counsel, party appointed arbitrator, commercial mediator, and arbitral secretary in both domestic and international arbitrations. She's the current president of the Tanzania Institute of Arbitrators and chairperson of the Africa-Asia Mediation Association. She currently serves as a member of the ICC International Court of Arbitration, representing Tanzania. She's a member of the ICC African Commission, the ICC Commission on Arbitration and ADR. She was recently appointed as a member of the IBA Africa Arbitration Network, and she's a member of the Pledge Africa Subcommittee. In 2019, she was awarded Top 50 Women in Management Award in Tanzania, and also awarded Top 50 Most Promising Young Arbitration Practitioner in 2020. Madeline is a renowned Africa-based industry futurist, adopting legal tech solutions, which she does with highly regarded iResolve, an ODR system launched in 2015, aimed at realizing her ambition to provide innovative delivery of legal solutions. And one remarkable thing about her, she once described the next generation as smart dispute resolvers. And Madeline routinely offers tailored trainings under the ILI Washington on ODR, online mediation, and virtual arbitration practical courses to various institutions. Thank you very much, Madeline, for agreeing to speak. You may now have the floor.
Thank you, Abayomi. Thank you for that very well articulated, or maybe very comprehensive introduction. Thank you so much. I'm privileged and grateful to have the opportunity to present today among the distinguished panel that I'm presenting with. I had, I think it was not chance, but it was by fate, a meeting Professor Wahab sometime back in 2018, if I recall correctly. And that really just, you know, with the ODR work that I had been starting to do, that really just sort of triggered a lot of energy for me to spearhead this in my country, and of course network out as best as I can on the African continent. So, you know, to what Professor has said to our participants is that imagination is the highest form of research, and this is what Albert Einstein stated. And I think I second that, and I fully accept the fact that it is only the imagination that would then take us that way forward in terms of invention. Now, what came about to me establishing an online dispute resolution? I'd like to start off with that first before going on to my presentation. Now, sometime back in 2014, I started my corporate law firm. It's a boutique firm, and I saw the need, having had transitioned from the banking industry, which is heavily tech driven, to a corporate self-standing law firm. I felt the need to include technology in the service stream to afford my clients that ease of access to the solutions that could be at the touch of your hand. As Professor explained, it really is a myriad of options that you have when you're using ICTs. Now, he's gone on and sort of explored that it's not only ICTs, but there are also these technologies that are evolving over time, which have evolved over time and are currently being utilized in various formats or in various sections of our dispute resolution systems. And that those technologies can be utilized not only by individual parties, but she's gone through the processes, through the spectrum of users, meaning B2B, B2C, G2G, and so on and so forth. And so that evolution is ongoing, but as he had put forward, it's been catalyzed by the pandemic. It's really just, we've leapfrogged from probably the mark of 30% usage to about 80% usage of technology in delivering our services, not only for me speaking as a lawyer in my legal work, but also as a dispute resolver. This is what we have seen. Litigants have had to take in e-filing formats from the court's establishment of e-filing rules. We've had to appear before a judge via a virtual court system. And so these changes have not only forced us now to become tech savvy, but also forced us to understand how do we then apply these technologies in our day-to-day businesses. And as SMEs, this comes in at a very important time, and this training is very crucial for your business to prosper in terms of dispute prevention, in terms of dispute management, in terms of avoiding disputes or minimizing the exposure that your business could have by utilizing these resources, which are really tech-driven resources. Now, I'll project my screen so that I am in time when it comes to sharing my screen. Hopefully that can be seen. And I hope you can see the screen in front of you with the first presentation slide. Can you confirm, Abayomi?
Yes, we can.
Okay. Now, as I said, iResolve initially started as a matter of a management tool. It has evolved over time, and it has incorporated other mechanisms or handling in terms of what the end user had requested. And so it was really reacting to the end user's needs. And so it started off as a management tool in terms of matter management. And then we developed closed chat rooms, which were then used more of a static form of communication. And these are now the past methods. If we look at what has happened, that was phase one. And then in phase two, we saw the need to incorporate not only payment methods, in collecting the neutrals payments, but also video conferencing facilities. Those have proved very difficult to incorporate into one system. And so some may need to drop off in order to use a third-party provider, as you would see later in my presentation. Now, just to kick off, I start off with Colin Rule, and I like starting off with this because it really just gets you to reflect and as Professor said, evolution, the process of change. What he said in the 2000s, just at the turn of the millennium, was that we see a bright future for ODR, a future which the value of ODR to all is so obvious that we will one day say, what took us so long? And I think this is the question in everyone's mind at this point in time. What took us so long? Did it have to be a pandemic that gets us to react in the manner that we have reacted by embracing technology to the levels that we have embraced technology? I think it did. And so that is proof in it all that we were very hesitant. And as you may recall from Professor's presentation, he said that when they started talking about this in the 90s, everyone would just smile and just nod their head and say, oh, okay, then we'll wait to see that. But then we've seen it happen. So ODR is not a new mode of dispute resolution. As presented earlier, it's using ICTs with the ADR mechanisms that we all know of. So there is no change to the ADR mechanisms that we are aware of. And we'll look at these in the spectrum, such as mediation, arbitration, and includes the hybrid processes that are contained in that ADR spectrum that we might be aware of, those who are participating. It is now the introduction of this fourth party, which is the state-of-the-art technology, or ICT, to either facilitate and assist the parties in the process, or as we've seen in the presentation, be actually incorporated fully into that dispute resolution process, such as the automated e-courts or blind bidding sort of processes or systems, which are really just automated and heavily supported by artificial intelligence. Now, for SMEs, and it was difficult today for me to prepare for my presentation, because for SMEs, we naturally know that disputes are may arise across borders between SMEs, and businesses are more familiar with the traditional arbitration or the traditional methods of resolving their disputes through the court systems, or the traditional arbitration in terms of face-to-face arbitration. But with technology, it can enable SMEs with the right procedures being adapted, of course, to heavily cost cut the entire process of resolving the disputes that may arise within that space, the SME space. Now, for example, providing that there is one arbitrator instead of three, or providing that the kind of disputes that would be going for physical meetings as opposed to virtual meetings. All these are thoughts that SME owners, SME managements should think of. What kind of disputes should be channeled through the traditional means, if at all they are not arbitrable, for example, or are not accepted in our legal environment, because as presented earlier, the enabling environment is really the national laws in which you operate. And if the national laws do not accommodate for e-processes in terms of maybe the Evidence Act, or having ICT laws that are advanced and in line with the Unicitral Electronic Commerce Model Law, then that would sort of maybe push you a little bit back. But processes may be adapted if you have a well thought out strategy in terms of your dispute resolution policy within your internal management systems. And that would be one key advice for SMEs when adapting or trying to transition into now utilizing remote ADR or ODR mechanisms. Now, what I have there in front of you is the ODR spectrum. And that's really outlining what I've just been speaking about in terms of the ODR being really just a mirroring of the ADR that we are all aware of in terms of the traditional formats, in traditional mechanisms that we are conversant about. Now, in terms of online, we've seen that ADR transitions to use of ICTs, or of course, state-of-the-art technologies, including AIs and supportive, other supportive technologies. And it could be online arbitration, online mediation. Of course, my spectrum has limited it, but it really could cover the whole range, including e-juries, e-courts, and the likes. And just before I move to the next slide, I think it's important to also speak about the fact that, yes, we have evolved, and due to this catalytic effect of the pandemic, we have leapfrogged. Now, if you look at the technical notes which the professor has referred to, now those technical notes could be very outdated at this point in time because of that speed that we've had to deal with over the past 18 months. And if you look at the technical notes, which are the Unicitral technical notes of 2017, yes, they were worked on during a period where we were seeing sort of a turtle-like, or very small, a small speed move towards entire integration of ODR into our ADR mechanisms. It was a slow movement. Now, with this kind of position that we're in, in terms of online dispute resolution at this stage when we're presenting to you, we really need to go back to those UNICITRAL technical notes and maybe reach out to the UN and say, okay, well, these were the classical approaches. These were the initial sort of past references. Now, what do we have to do? Of course, it's a non-binding document, as pointed out earlier, but they need to be reformulated in order now to take advantage of the fact now that we have arbitration that is for example, what I wanted to refer to was blockchain arbitration. Sorry, the word had sort of flown off there. Blockchain arbitration, automated online dispute resolution mechanisms that were probably not thought of at that time. We've got this cryptocurrencies also being implemented in not only in the African continent, but elsewhere. We've seen this already, a booming need for cryptocurrencies, and there's several ones that are available. And so these have really pushed back the UNICITRAL notes to being slightly antiquated at this point in time. And that's just a point I wanted to make on the UNICITRAL technical notes. Now, with the spectrum that we were looking at, you could consider several factors: the relationship of the parties, the time being of essence, the goal being that you want to resolve cost effectively, and of course the geographical elements or limitations and restrictions that could be privy to your particular dispute. And then, of course, the kind of documentation. And so these are considerations when you're considering shifting from the traditional to the now online sort of remote process, which is ODR. Now, online dispute resolution, as presented, could be through different methods. We've spoken about emails, we've spoken about closed chats, video conferencing, and that's really just one of those elements that could be the driving factor behind the ODR system in use. Sometimes in the experience of iResolve, what we find is that there's the need for a combination of the two. And why a combination of the two? It really does go back to the essence of ODR, being the top of the pyramid, or the top requirement being the trust issue. And with ODR providers such as iResolve, the building trust and having the end user trust the system is one of critical importance for you to be able to say that users have that comfort that their data or the levels of security that is required for their data to be protected. Now, including trust seals, including other certifications that could provide that comfort or build that trust among the end users. And when I speak of the end users, it is you, the SMEs, or the ADR providers and practitioners, ADR practitioners who are using the ODR platform to perform the particular mechanism on an ICT-based or on a technology-based platform. In my next slide, I thought of having to also emphasize on the two types of ODR. And in many writings, and if you read the books referred to by Dr. Wahab, Professor Wahab, they really are very comprehensive when they're touching on the synchronous and asynchronous methods, whereby the synchronous methods communication is all about the communication being used for the resolution of that disputes. Online parties, however, have the possibility of maybe using both, as I said earlier, both discussion forums, for example, emails and testing. And this was traditionally what we witnessed. Arbitrators would get their appointments through email, They would be able to drive the process by email, and only meet the parties when they call upon, for example, the preliminary meeting, and of course the hearing. But all a while over the past, we have seen the use of both these methods, and it is really not a new breed. Now, on the ODR process map, being that I'm speaking as an ODR provider, I find it useful to also make you aware of the process. So each ODR provider would have their own processes, and not only their own processes, but they would have their own terms and conditions attached to those processes. And so if you're going to be utilizing these ODR platforms, that particular background research, the same way that you would do when either instituting a mediation or an arbitration at a particular center, then this is the same kind of research that I would advise ADR practitioners to do. And SMEs in implementing your dispute resolution processes, your internal dispute resolution processes or external dispute resolution processes, that you'd have to consider which providers best suit the kind of disputes that are generated from your kind of business. I think this is a very important question for those SMEs that are available here today for this particular webinar. Now, what you can see there is just the process map where you have from the lodging of the dispute or the claim. And I find that the ODR providers are more prone to the small claims, and not only the small claims, but also the consumer-based disputes that are usually sort of government to consumer or business to consumer based disputes. And they work well in that manner because of that element of being mandatory, maybe are provided for by a particular statute. And so they tend to pick up more if an ODR provider is attached to a particular government organization or a business that is required by statute to provide consumer dispute resolution access to their consumers. And then once you've lodged your dispute, you of course go by the rules of that ODR provider. If they have particular rules of procedure, then they would probably, for iResolve, what we do is appoint a particular ADR specialist who would then assess whether this is a mediation or does it channel through to the arbitration or any other form of ADR. And then a respondent would then be notified, and that notification is usually by email. And so when you're lodging, that particular format would require you to enter the details of the respondent. And with that, then the respondent would either respond, and most of the times they would not respond because they would wonder, what is this? What is this iResolve? They'll probably give it a little bit of a hard time until they do end up either showing up near to the end, or at least sending in their personal physically. This is what we've experienced before, but with the pandemic, we find that there's a more positive acceptance. Then the filing of the position statements, if it's mediation, or the pleadings, can be done on that ODR platform if it provides for such storage. Some ODR providers don't have the storage or for storing the info, for storing the exchange of pleadings or the exchanged pleadings and documentary evidence. But there are third-party providers that could be integrated into that process by the parties. Now, oral hearings, or as we will hear more about them for arbitration from Isaiah, those then would follow in a mediation. It would be a mediation session where you actually meet with the mediator in an online environment or physical. Now, if they opt for physical, then the parties really would then meet physically in the process that we have. But if it isn't a fully implemented online dispute resolution process, then that would be conducted virtually. Then we get to the settlement and the decision, or if it's an adjudication, and then or their final award in terms of an arbitration procedure. this is the vision that an ODR platform would really look like if you look at it in terms of picture. Now, you'd see that we've put an ODR administrator who is also provided for under technical notes 27 of the UNICITRAL or technical notes on ODR. And with the notes, it describes an ODR administrator to be an entity that carries out such administration and coordination of that particular process. And with an ODR platform, there should be that administered or coordinated function, and either embedded in the system or may be a separate from that particular platform. And so that really depends on the platform that you would be using. Now, the technical notes go further also to elaborate on the different roles of the platform and the administrator. Of course, the platform itself, as I said earlier, and you can see there on the slide, is a system for generating, sending, receiving, storing, exchanging, or otherwise processing the communications in a manner that ensures data security. And that's the wording of the technical note 26. Now, we move on to looking at much more length online mediation. And online mediation has been defined by several literatures. And I haven't come across one that really fits online mediation. So I've put several bullet points in front of you. And the first one goes, it is a system-based as opposed to a face-to-face based mechanism in which an impartial third party called the mediator facilitates the negotiation process between two or more people. Then it goes on to say in the bullet that follows it is supported by the internet, whole process versus parts of the process. Different types of e-mediation then would fall in there. Then you go on to the third bullet, and it says there that the use of general, so this is telephone, so this is the past, if we're speaking on what the presentation just took place. This is the past where we're using telephones, faxes, our PCs, email exchanges, but now there is that video conferencing, there's AI and the rest, enhancing the use of the AI enhances the use of that technology. Then, and for unspecified, it says that unspecified limited electronic technology, or it is a cloud-based environment. Now, what the statement that is bolded there in red says is that it strongly resembles offline counterparts, and that's why mediation, online mediation, is often really seen to have taken more accommodated more electronic means, because it really it doesn't have those procedural aspects of an arbitration, for example. And this is, as you can see, there's a flexibility in terms of driving the process in an online environment, and the possibilities there then make it much more easier to adapt or mirror it in a technology-based mean. Some examples we've seen in the past presentation, and these are automated software programs. There's One Accord, Web Mediate, Internet Neutral, BBB Online. These are past automated software programs. Some, of course, still in place. We've spoken about the closed chat rooms and the virtual versions of meeting rooms. These are really virtual versions of meeting rooms, but really it is more static as opposed to the video conferencing, where you see a projection of who you are you're conversating with. Now, the electronic tools also, if we read Bellucci and Zelenko, COV, if I say the name correctly, the electronic tools enable increased flexibility because virtual mediation sometimes becomes electronic mediation, negotiation, and vice versa. Mediation is a facilitated negotiation. And so those tools that could be utilized in terms of facilitating that negotiation could be applied by way either synchronous or asynchronous means. Now, in a mediation, one could consider these issues. There's less control over physical environment. There's reliance on the technology. And then, of course, there's no control over the participants' environment. So you're unable to control the environment as where if you were in an offline environment where you're meeting in a room. For example, for mediators, we find it very difficult to build that rapport initially because in an online environment, building rapport is slightly more complex as opposed to having those who are mediating in front of you come to your chambers for a mediation where you could build rapport immediately upon them entering the room by just a mere way of how you invite them into that room. But in an online environment, you would have to adapt a different skill set, and that skill set that to build rapport is really depending on the mediator. Some mediators prefer having initial preliminary meetings to just know the parties, understand the technology, and build confidence in the use of that technology. Now, moving on to e-arbitration or online arbitration. And virtual or remote hearings, it would be very different if, as you can see in this particular diagram, where you have different definitions, where if you speak of remote, this is using the technology which allows two or more locations to interact simultaneously by two-way video and audio transmission, facilitating the communication and the personal interaction between those two locations those persons are seated. And this is directly from the Hague Conference on Private International Law guide to good practice on the use of video link under the Evidence Convention 2020. This is how they describe remote, the word remote hearing. Then when you move on to the virtual hearing, and that's why we have to differentiate what do we mean by ODR? And we can't all align in terms of what is ODR. If you go back to virtual, it's telling you there, if you look at the Oxford Dictionary, is that not physically present as such, but made by software to appear to be so from the point of view of a program or user. That would then get you to rethink that virtuality of that particular proceeding. Then you've got your semi-remote hearings, which we will touch on, is that one side or its witnesses or the experts participates remotely, but the others do not. And this does happen, especially in international arbitration, where it is really the parties are positioned in different ends of the world. Now, online hearings, we've been hearing about online hearings, it's an overlap with ODR and online courts, hence could be also slightly confusing. For example, online court, the virtual hearing is a court hearing conducted by audio-visual means, meaning the virtual court system, where cases are sort of processed without the need for participants to attend court in person. And that's from the Supreme Court of Victoria in Australia, 2020. So that's where they define, how they define online courts. Slightly different from the ODR that we are speaking about. Now, when you're strategizing to moving remotely from the traditional And I think the speaker that follows will speak more when it comes to remote arbitration. When you're strategizing for ADR in general to move to virtual, you would need to take into account some of these itemized items on this bullet, on this particular slide. The party's right to equal treatment and, of course, the right to be heard if it's an arbitration, identifying the issues, eliminating oral hearings if it's possible, and that really does take us to my next slide, which is about documents only arbitration, limiting the written submissions between the parties, and limiting oral hearings. I think that's also replicating the bullet point before that, limiting the evidence being produced by the parties, and of course having that innovative option available for the participants in that dispute resolution process. Eliminating oral hearings could be done by agreement of the parties. And if no agreement, then that also could be decided upon in terms of a tribunal, by the tribunal if it's an arbitration. Limiting the written submissions, that could be challenging, but it's doable in your, as an arbitrator, for example. What we would do is we would advise parties to limit maybe submissions to a couple of pages, as opposed to having to go their way in submitting heavy submissions. Innovating options, having that flexibility to accept the use of technologies available. In a documents-only arbitration, and this is an option to parties who are conducting, who are in an arbitral proceedings, they may opt to agree for their disputes to be decided upon without oral hearing. And the benefits of that, as presented in that slide, is that there will be these would be low to medium value disputes, and this would cut the costs and maintain that cost cutting effect in terms of now applying a documents only arbitration. Of course, the parties would rely only on the written submissions, and they would not have any hearing. That's the downfall for that. And some national laws and arbitration rules could also provide for how this could be implemented well. Some guides are also available, especially the Chartered Institute of Arbitrators guidelines on documents-only arbitration procedures. I think that's a very good go-to document if you're going to adapt a documents-only arbitration. And I think a documents-only arbitration works well for an SME kind of related dispute. What I find is that the disputes usually maybe not heavy big data sort of kind of disputes, and not very complex. But if it is complex disputes, then you find that the arbitrator at some point may need to have maybe that oral hearing conducted in order for them to get the grip of what is the underlying dispute, or what is the underlying complexity that they are unable to understand. Just to get clarification, they may order for an oral hearing, and of course the parties would have to agree to that. Now, one good example is the domain dispute resolution process under the WIPO Mediation and Arbitration Center. I think this has really solidified the way of which documents only adjudicated or arbitration process could work very well. And that, of course, is under the ICANN structure of domain dispute resolution policy, the UNDRP. And so that is a good example of why a document-only arbitration could be successful for the kind of dispute that you would find would be much more accommodative of that kind of structure. Now, avoiding challenges, and I know that the next speaker would speak more on party participation and the party's consent, but I would like to highlight also some cases that are touching on the right to be heard. So in an arbitration, for example, parties, the key underlying principle there of right to be heard has to be observed, and there's some courts have held that there would be no breach of the Article 5 of the 1B of the New York Convention. Remote hearings in and of themselves are no issue under the particular article in another case. And so as long as parties are being provided with that room and opportunity, then there will be less chances of having an arbitral award challenged in the court of law. Then we move on to the next bullet, which is the right to be treated equally. Now, this is also an issue which could raise challenges in terms of arbitrations now. And in an online environment, the same levels of applicability of the right to be treated equally would need to be observed as in the traditional forms of ADR, of arbitration. And so inequality in technology means what the sole protocol, and this is a protocol on virtual hearings that is available online, is that the tribunal may terminate the video conference at any time if the tribunal deems the video conference to so unsatisfactory that it is unfair to either party to continue. And so this comes about maybe usually at the point where you have a participant who's unable to use the technology and you proceed on using technology despite that fact. And so that could amount to inequality. And then the restrictions on travel, of course, they could adapt the semi-virtual, some in person, others remotely. And there's a good guidance provided for under the Chartered Institute of Arbitrators guidance notes on remote proceedings that was produced in 2020. And that note goes on to say that in the interest of equality, it is preferable that if one party must appear to the tribunal remotely, both parties should do so. Now, just preliminary considerations, and I hope I still have some time to go through the preliminary considerations when now you're shifting from the traditional to the remote applicability of that ADR mechanism. You have to select the technology, and cost is one issue for one to consider. Most of the essentials of a virtual arbitration can be fulfilled by free versions, but free versions won't allow you to do a lot. It will just give you the basic features. And so selecting the technology is very important because there's the cost element, and that cost element either has to be borne by the parties equally or as agreed. And so the practical considerations would then be next, whereby the participants' technical abilities, as I said earlier, the data security and confidentiality, the technology efficiencies, where we spoke of the ICT's infrastructures in Africa, picking up speed in terms of becoming more effective, but there's still interruption, there's still low quality internet that would hinder a participant in that particular arbitration or mediation to efficiently take part. Then there's the breakout rooms and the need to subgroup some of the members, maybe from experts to the arbitrators themselves having their own breakout room for deliberation. All these are technology efficiencies that one would need to consider having in that technology that they select. And of course, the cost element, as indicated prior. The technical disruptions, that is something that we have seen happen a lot of times. We've even seen the same happen in just a mere webinar. And so having a backup plan is highly encouraged. And those backup plans are evidenced even in the several protocols and models or guidance notes that have been issued by several organizations, including the Africa AAA protocol. The logistics and the preparatory arrangements, of course, these are heavy works when it comes to the online remotely driven dispute resolution mechanisms, because you have to prepare. You have to be you have to have tested the platform. You have to be ready to use or utilize large or multiple screens, and being able to navigate through the softwares and the hardware that is in front of you. And so it is difficult work, not only for the neutral, but also for the participants who are the parties and their representatives. And so being aware, having those arrangements being made in advance is critical. And I wouldn't go over each item of this particular slide. Now, preparing for remoteness, in conclusion, is considering the nature of that dispute, having the parties participating, having the same levels of know-how in using that technology is very important. Having that informed participation and secured party consent is of critical importance. And of course, checking and ensuring that the particular dispute at hand, the particular governing law that is applicable enables you to utilize remote means of resolving your disputes. Of course, at this point in time, national laws have advanced over the couple of years, and they do allow for electronic transactions, they do allow for electronic evidence, and so we don't face a lot of challenge in terms of that. But each jurisdiction would have its own issues. Consider the institutional rules, if you're going to have institutional rules applicable, or utilize maybe the rules of the ADR provider, because the ADR provider could have rules that could be sufficient for your cause. And then, of course, having a tech-savvy neutral. When you're electing or selecting your neutral, ensure that the neutral is able to adapt to the technology. And of course, as a last point there, is that in any process that goes remotely, it is very helpful to adapt either a protocol or a guide that could assist in the process, especially when you are encountering a problem in using technology to assist in terms of resolving your disputes. And I think that's where I end with my presentation, and I hope I have been able to advise the SMEs and the ADR practitioners in terms of utilizing ODR in resolving their disputes. Thank you.
Thank you very much, Madeline, for those useful insights.